Jurors themselves. One juror says it was wild, with people yelling and screaming as they tried to decide the fate of Michael Dunn, the man accused of murdering 17-year-old Jordan Davis. Another juror also says things got pretty intense. Listen to what these jurors say about the role of race in this trial and how they made this very difficult decision.
I never once thought about, oh, this was a black kid, this was a white guy, because that wasn't the case.
So people who say, here's another white guy who got away with shooting and killing a black kid, what would you tell them?
I would tell them that they really should acknowledge themselves on the law.
Do you think Michael Dunn got away with murder?
At this point, I do, myself personally, yes.
When you went to the deliberating room, you thought Michael Dunn was guilty?
Yes, sir.
Of killing a 17-year-old boy?
Yes, sir.
What convinced you of that?
To me, it was unnecessary.
You didn't think Michael Dunn had to kill Jordan Davis?
I don't believe so.
In the end, the jurors didn't agree that Michael Dunn was guilty of first-degree murder, and the judge declared a mistrial on that charge. Let's bring in our legal guys. Avery Friedman, a civil rights attorney and law professor, joining us from Cleveland, and Richard Herman, a New York criminal defense attorney and law professor, joining us from Las Vegas. Good to see you, gentlemen.
Hi, Frederica.
I see you, Frederica.
Okay, so Avery, you first, what you learned about this jury's decision, just listening now to these jurors about what was taking place behind closed doors, what they omitted, what they thought was not present, and what they thought was present in this case.
Well, often in jury litigation, Frederica, you will have stronger jurors and jurors that are less assertive. And I heard the remarks by some of the jurors, by two of the jurors, and it seems impossible to me that race was not a consideration. To me, if you had a remorseless black guy that shot a white guy like that, there would be no question of first-degree murder. And I actually believe that Michael Dunn literally got away, at least with first-degree murder, got away with it. And frankly, I think the prosecution is right. The state attorney is right. It's time to retry this case for first degree.
And so, Richard, as you listen to the jurors, the way in which the jurors applied the law based on what was presented in court, do you think that this underscores the glaring, mistakes made by the prosecution, that perhaps they didn't connect the dots enough for these jurors, they didn't paint the picture so that these jurors would go into, deliberations a little bit better equipped with the facts or all those circumstances that may have been surrounding this event, this shooting?
That's a great question, Fred. Let me answer in two parts. First, with respect to race, that's the challenge in jury selection or voir dire, to determine whether or not any jurors come in with personal biases. You want a juror to come in with a clear head, not to have personal biases. It's virtually impossible to detect that, Fred. That's number one. And here, I don't know if that played a role in this or not. But number two, I don't know that the prosecution made that big of a mistake. There was a self-defense claim here. And had Jordan Davis come out of the car with an assault rifle, an AK-47 or a shotgun,
it would have been easy.
Would Dunn have had the right to be able to shoot him at that point? Because that's basically what the defense of self-defense in this case was. Three of those jurors believed that he came out of the car with some sort of weapon, thereby allowing Dunn to shoot. Now, they did not find the weapon. And in like the Trayvon Martin case, where actually Zimmerman had cuts behind his head to somehow corroborate the fact that he was being beaten at the time, here, there was no evidence to corroborate whether or not Mr. Davis came out of the vehicle with a gun. That's why it's so hard for people to accept. But it was self-defense that prevailed for three of those jurors, Fred.
Okay, so we heard from the jurors. We also had a chance to hear from the Florida prosecutor, Angela Corey. She says she will indeed seek a new trial for Michael Dunn on the murder charge. This is what she told our Chris Cuomo.
Our intention is to retry count one for all the reasons I stated earlier, because Jordan Davis deserves justice, because the state of Florida deserves justice, and because we always like to have that backup case where a person gets consecutive time in case something happens on the other charges.
Avery, what strikes you as interesting about those comments? The fact that she said it's good to have a backup?
Yeah, in case of procedural errors or substantive errors on appeal. But you know what? There's something even deeper than that. And Ms. Corey said this with Chris Cuomo. She said it's time to change the stand your ground law. Not because it was involved in this case, but Frederica, it generates a sense, a mentality that it's okay, have that gun ready. The law should be a duty to retreat. And even though this was a self-defense case, we agree on that. The idea of stand your ground being in Florida as part of the law, it's time for a change. The state attorney is right, and it's time to go back to duty to retreat.
All right, Richard, last word on that?
Fred. Yeah, Fred, Miss Corey left out another big reason to retry it, and that is to save her job, because that's the reason this case is being retried, in my opinion. Although, when a verdict comes in with 3 dissenters like this, usually the prosecution will take another look at it. If it came in half and half, they would probably let it go. But here, I believe the retrial was politically motivated. I don't know that it's warranted here, and you may very well, Fred, get the exact same result next time.